My name is Jesse Schley, and I am in my third and final year at the University of Pennsylvania Law School. Today I will be discussing the 2003 case of Lawrence v. Texas with you. In this case, the Supreme Court held that laws prohibiting private homosexual activity between consenting adults are unconstitutional under the 14th Amendment. Before looking at the facts of this case, it is important to cover some of the background information on this area of the law. In 1960, every state in America had an anti-sodomy law. Legal punishments for violating these laws included heavy fines, prison sentences, or both. Further, heterosexual relationships also had laws regulating their private activity. This started to change in 1965 with the case of Griswold v. Connecticut, where the Supreme Court struck down a law that prohibited the use of contraceptives by married couples. The Supreme Court recognized, for the first time, that a married couple had a right to privacy. A few years later, in 1972, the case of Eisenstadt v. Bayard expanded the scope of sexual privacy rights to unmarried persons. And in 1973, the Supreme Court held that the Constitution protects the right to have an abortion in Roe v. Wade. However, in Bowers v. Hardwick, decided in 1986, the Supreme Court upheld a Georgia anti-sodomy law, emphasizing that its past privacy decisions, like Eisenstadt and Roe, only recognized a right to engage in procreative sexual activity. Furthermore, the court found that the long-standing moral disapproval towards homosexual activity was enough to argue against the notion of a right to sodomy. By the time of Lawrence v. Texas, in 2003, 10 states still banned consensual sodomy regardless of the sex of those involved, and 4 states prohibited same-sex couples from engaging in any consensual sexual relations. With the law outlined, back in 1988, Houston police responded to a call for a weapons disturbance at John Lawrence's apartment. They entered the unlocked apartment and witnessed Lawrence engaging in a private, consensual sexual act with another adult man. Both were arrested and convicted of deviant sexual intercourse in violation of a Texas statute forbidding 2 persons of the same sex to engage in certain intimate sexual conduct. Lawrence pled no contest to the charges and waived his right to a trial and was found guilty and fined. Assisted by Lambda Legal, a gay rights advocacy group, Lawrence appealed. However, the courts of appeal in Texas affirmed his conviction. Lawrence then petitioned the Supreme Court of the United States, which agreed to hear his case. The key issue before the Supreme Court, and before you now, is whether the Constitution protects the right for consenting adults to engage in certain private sexual activities. In their majority opinion, 5 Supreme Court justices held that the Texas statute violated the 14th Amendment's guarantee that no state shall deprive any person of life, liberty, or property without due process of law. According to Justice Kennedy, in the years since Bowers, attitudes towards homosexuality had changed, and the court's understanding of the right to privacy had been expanded. Thus, the court overruled the 1986 decision in Bowers. This is noteworthy because of the importance of stare decisis. Stare decisis is the legal doctrine that requires courts to follow decisions in previous cases, called precedent, when making a ruling on a similar case. Stare decisis ensures that cases with similar scenarios and facts are approached in the same way. However, the Supreme Court may overturn precedent. Usually, before precedent is overturned explicitly, a series of previous decisions have served to erode its holding. So, what do you think? Has the right to privacy been expanded enough to erode the court's decision in Bowers?